Good morning, everyone, and thank you for joining today's webinar. A few months ago, James attended our National Healthcare Team meeting where he walked us through 8 of 28 significant reforms being introduced by the Employment Rights Bill. And what quickly became apparent was that actually collectively, these changes are going to increase operator costs further, especially in the current climate where increases in national living wage and NI contributions are already squeezing margins. And we won't even speculate too much about what further pressures will arise from the upcoming budget. But with all this in mind, today's session is designed to share some insights and help you consider how these changes might affect your businesses. And on that note, I'll now hand over to James to take us through his presentation, which will be followed by a few words from Derek, our Head of Healthcare, and then we'll open up a Q&A session. Please feel free throughout the session to drop any questions into the Q&A function. So James, over to you. Thank you.
Thank you very much, and good morning, everyone. Thanks for joining us. We've still got I'm still getting lots of pings of people. My name's James Sage. I'm the Joint Head of Health and Social Care at RWK Goodman. Our health and social care team specialises in providing a full range of legal and regulatory services to care providers. My expertise is in HR and employment law, and I'm today just going to give you an update on what I think are the most significant parts of the Fair Pay Agreement. I've got a summary here. It's what we're calling the Big Eight. So firstly, we're going to just look at Fair Pay Agreements, reforms to sick pay, changes to 0 hours contracts, changes to unfair dismissal rights, new trade union laws, some new liabilities around third-party harassment, changes to fire and rehiring, and lastly, a look at the new Fair Work Agency. Fair Pay Agreements. So this is a really significant and new development for the sector. Effectively, what this is sectorial collective bargaining, where there's going to be the creation of a new central negotiating body made up of trade union representatives and employer representatives to effectively negotiate terms and conditions for care workers that will apply across the sector as a matter of law and which will be required to implement. The proposals currently are that the Care Provider Alliance will will have responsibility for providing the relevant people to negotiate on behalf of employers, but that's yet to be determined. And there is a consultation live on this Fair Pay Agreement at the moment, and this is one of the things they're going to consider. The purpose of the Fair Pay Agreement is to agree remuneration, terms and conditions, and any other matters relating to terms and conditions. And in the consultation and the impact assessment, it's quite interesting what's being talked about as potentially in scope for a part of that negotiation. So as you'd expect, hourly rates of pay are significant. Going to be looking at potentially providing a new hourly rate of pay above the national living wage, which would apply to care workers, looking at whether there'll be different pay scales within the sector or whether there will just be a higher floor rate that would apply above the national living wage. Obviously, these additional payments would be on top of the national living wage increases, and the impact assessment that the government's released suggests that based on the funding available, the pay just on the Fair Pay Agreement element could increase by 2.8% under the first Fair Pay Agreement. And as I said, that would be on top of the national living wage increases. So quite potentially significant additional costs. But it's not just limited to pay. There's also the possibility that other terms like holiday pay, sick pay, pension contributions will be in scope to be looked at. Other things such as travel time, particularly in home care, to ensure that that's paid as an hourly rate for every time spent travelling, rather than just paying for the contact time and offsetting against travel. Also, renewed talk about sleep-in shifts and making them subject to this new hourly rate. And so for those of us who thought we'd seen the last of sleep-ins being an issue when the MENCAP case had been concluded, that looks like it's back on the table again. Who's in scope for this? Well, it's really broad. The current consultation proposal is that it's anyone employed in the provision of adult social care, and that would include someone who's in an ancillary role. Funding is as you'd expect, big question in relation to the Fair Pay Agreement. So how is it going to be funded? The government is currently, or has currently, aligned or provided 500 million to fund the first Fair Pay Agreement. But when you look into the detail of the impact assessment, it's quite interesting to see how it's actually going to be funded. So the expectation from the government is that the local authority would fund 52%, NHS would fund 17%, and the employer and self-funders are going to be funding the remaining 31%. So for those hoping that this would be fully funded by the government, as it stands, that is unlikely to be the outcome. And so it's really important that you all contribute to this consultation around, particularly around this point around funding. And the impact assessment refers to the fact that particularly smaller providers may struggle to have sufficient profit to fund the impact of the Fair Pay Agreement. I would recommend, so as I said, recommend doing the completing the consultation. I think the deadline is beginning to middle of January, but have a look at the impact assessment first, because there is some interesting data in that. So the next big change is around statutory sick pay. The proposal is that the waiting period of 3 days where SSP is currently not payable is going to be removed. So SSP would be payable from day one. And also to remove the lower earnings limit. So currently someone has to earn £125 a week in order to be eligible for SSP, but that would be removed. So the impact of those is that there's going to be additional cost from SSP perspective, but also there's going to be a broader group of people who are eligible for SSP. SSP payments will be either the current SSP rate or 80% of someone's weekly pay if it's lower than that. So what can you do to start preparing for this? Because the plan currently is that this is coming into force in April next year. I think it's well worth looking at what your sickness absence has been over the previous 12 months and see if you can estimate and budget what the additional costs would be based on the new rules being in place. So do a kind of 12-month audit. It's also going to be worth reviewing the effectiveness of your sickness absence management policies to try and avoid increased absence as a result of the first 3 days now being payable. Also worth thinking about training for managers to ensure that those sickness absence processes are being followed in a kind of robust way. I think this has quite a significant potential impact because what we see is that most sickness absences are in that first 1 to 3 day period. So the cost could be significant. And I've done just a little kind of scenario for you, just to give an idea of how this could work. So if you've an organisation with 300 employees, on average, each employee takes 5 sick days per year, which seems quite reasonable. Some will obviously take a lot more. Then that is going to provide 1,500 days of sick leave per year. And if we assume that all of those sick days are within the first 1 and 3 days, under the current statutory sick pay rules, then you're not going to have any SSP cost because it's only payable from day 4. In the future, assuming that those employees work 5 days per week, then the new SSP cost would be £35,625. And this doesn't account for the additional people that will be in scope as a result of the removal of the lower earnings limit. If you had employees working 3 days a week rather than 5, the pro rata SSP element is going to be higher, so that you could be looking at costs nearer 59,000. Obviously, if you've got staff who are working more days, taking more days sick leave per year, then the cost will go higher. If you have more employees in your organisation, so if you have 1,000 employees and they're doing 5 days, they're working 5 days per week and they're having 5 days absence per year, you've got 5,000 sick days a year, and you're looking at a new cost of 118,750. So these are costs, additional costs that you want to start thinking about now and start kind of budgeting for. The next change is around 0 hours contracts and there being increased regulation of how you can use these. The first proposal is to require you to offer someone on a 0 hours contract a guaranteed hours contract after they've worked 12 weeks with you. The next is to provide reasonable notice of shifts. We don't yet know how long that would be. It could be double the time, but that will be confirmed in subsequent regulations. I think where that's quite tricky is where you're using 0 hours workers to cover sickness absence. So if you're doing it for holiday, you probably get a bit of notice and that shouldn't be a problem. But if you're looking to cover last minute sickness absence, which is why a lot of people use 0 hours casual bank contracts, then how you're going to be able to comply with this requirement to give reasonable notice is yet to be seen. There's also a proposal requiring you to give compensation if you cancel shifts at short notice for a 0 hours or casual hours worker. So who's in scope for this? Well, it will be your 0 hours employees, so someone who's on an employee contract, but there's no guaranteed hours, but also casual and bank workers. So there's different employment status there. You've got employees and casual workers. And the effect of one of the casual workers accepting the offer of guaranteed hours would be that ultimately it would change their employment status. So they'd no longer be a worker, they'd be an employee. Agency workers are also in scope. So if you had an agency worker working for you for 12 weeks, you offered them a guaranteed hours contract. If they accepted it, then again, they would become your direct employee. We think, based on the kind of work we've done with providers over the years, that this is likely to have much more of a significant impact on the home care side than it would on the residential side of the sector. We've done lots of projects on the residential side to try and get casual bank workers onto permanent employee contracts. And on the whole, they don't want to do that because they're very happy with the flexibility and casual nature of that arrangement. In contrast, on the home care side, I think because of the way those services are commissioned, a lot more people are on 0 hours employee contracts because the employer has required them to be on that type of a contract because they can't guarantee the work because of how it's commissioned. And I think there could be much more demand on that side for guaranteed hours contracts. So what can you do to kind of plan for this? First one is to just kind of analyze the existing use of 0 hours and casual worker contracts so you can understand how affected you're going to be. You could potentially start looking at what the cost implications would be of having to offer a guaranteed hours contract, or if you're going to be, based on how often you cancel shifts. We obviously don't know what the compensation is going to be for that yet, but you could try and do some modelling. There will also be a need to review the procedures that you have in place for offering, accepting and rejecting shifts, so you can minimise any of these potential kind of additional costs. And there will definitely be a need, once we've got the regulations which set out more detail of how these rules are going to apply, a need to train managers who are responsible for managing shifts within your organisations. The next one is changes to unfair dismissal rights. This is probably the one that's probably had the most press coverage. As we know, the current position is that, save for some limited exceptions, an employee needs 2 years service in order to bring an unfair dismissal claim. But the proposal under the Employment Rights Bill is that the 2-year qualifying period would be abolished and employees would be able to bring an unfair dismissal claim from day one. This is something that has kind of yo-yoed depending on previous governments. So we've previously had it at 1 year. We've also had it at 6 months. More recently, it's been at 2 years, but the proposal is that it would be a day one right. The Employment Rights Bill indicates that there would be an initial period of employment, or a kind of statutory probationary period, which is suggested could be 9 months, during which time there would be a modified dismissal process, so kind of a light dismissal process. And provided you followed that, then you could dismiss without the risk of an unfair dismissal claim. That would apply for all dismissals except for redundancy, for which you'd have to continue to follow the current redundancy processes from day one. So that might provide some assistance, but on the other hand, it could just create additional complexity, because ultimately you've got 2 different processes that you have to apply if you're looking to dismiss someone. There's also a proposal to extend the limitation period for bringing an employment tribunal claim from fair dismissal. Currently that's 3 months, but there's a proposal to extend that to 6 months. So the impact of this is the likelihood of more employment tribunal claims, and also increased management time and cost of dealing with those. And this is also problematic because there is such a big backlog of employment tribunal claims in the tribunal system. It's not unusual now for us to have a claim being listed for a hearing in 2 years' time, particularly in the Southeast employment tribunals. And that seems like that is only going to get worse. So what's your kind of action plan to start preparing for this? The first one probably is looking at recruitment processes, making sure they're as effective as possible, because the risk of taking on staff is going to be greater now. So you want to make sure that you've got as robust a screening and recruitment process as possible. Second one is training managers on the new processes. So dealing with this probationary period or this light dismissal process, for example. There will be a need to update staff contracts and policies and handbooks nearer the time when we have a bit more information. And there is going to be a fundamental change, I think, in the role of the manager in this initial period of employment. At the moment, if that onboarding and probationary period isn't properly managed, there isn't a huge amount of risk because the employee still needs 2 years service in order to bring a claim. Going forward with day one unfair dismissal rights, there's going to be a much greater need for managers to ensure that they're really proactively dealing with performance, sickness, conduct issues during that initial period of employment, so that they then have the necessary evidence or grounds in order to effect a fair dismissal. You also need to be thinking about potential strategy for dealing with the increased risk of claims, particularly if you're a large organisation with a lot of employees. And that might involve looking at what kind of employment advice services you've got in place, what insurance you've got in place as well to cover the risk of claims. We've also got some changes around the rights of trade unions being brought in. So there's 3 main elements to this. The first one is a new requirement on employers to provide a written statement of the right to join a trade union. The second one is increased rights of access to the workplace for trade unions. And the third is lowering the thresholds for trade union recognition. On the recognition point, currently there aren't a lot of care providers that formally recognise a trade union. Some of the very large corporates do, a fair number of charity, not-for-profit providers do, but on the whole, it's a relatively small number. Generally, how this works is that if a trade union thinks that they've got employees within an organisation who would want to recognise, they'll approach the employer and suggest a voluntary recognition. And if you can agree that, then they will be negotiating with you over terms and conditions on an annual basis on behalf of the workforce or a part of the workforce. If you don't agree to that, if they've got sufficient support amongst employees, then they could apply for statutory recognition from the Central Arbitration Committee. And what that would mean is that recognition is effectively forced upon you, and you would then have to negotiate and bargain with the unions on an annual basis. What the change under the Employment Rights Bill is doing is just lowering the thresholds that the union would need in terms of the amount of support they've got within your organisation in order to get a statutory recognition. So what's the impact of this, and what can you start thinking about now? The impact of having a formally recognised union, because we work with a number of providers who do have that, is additional management time and resource, particularly around the collective bargaining time of the year, but more generally as well. There's also, pressure on you around pay rates and other terms and conditions on an annual basis, and in extreme cases there could be the risk of strike action if you don't reach agreement. So what can you do to start planning? I think the first one is think about how you would manage an approach from a trade union. So if you had them knocking on the door, which providers are experiencing, how are you going to deal with that? Have you thought in advance about whether that's a route you're willing to go down? Do you have a preferred trade union, or how are you going to manage that relationship so that you don't damage it in the event that potentially in the future they do become a recognised union? So there's some pre-planning you can do on that. The other is think if you're of the view that you'd really rather avoid having a recognised trade union, then you could think about how you might be able to prevent that. Something that we're working with a number of providers on at the moment is putting in place an internal workforce representative body, so kind of like an employee forum, with the aim that if the workforce have got a direct line into senior management team to discuss issues at work or pay or other things, then that might reduce the risk of them wanting to have a formally recognised union. In reality, the unions are likely to be targeting the largest employers first under this, when these changes come in first. So I think you're at more risk if you're a larger employer. But it's very clear in the Employment Rights Bill and through the Fair Pay Agreement documentation that the future aim is a much greater role for trade unions within the sector. And obviously they're going to be on the negotiating body. So in order to legitimise their position on the negotiating body, they're going to want to have as many formally recognised providers as possible. There's also some new changes around harassment law. So you know that we've all recently had a new duty to prevent sexual harassment in the workplace, and you have a defence if you've taken reasonable steps to prevent that. The new duty on sexual harassment includes a duty to prevent harassment by third parties, but there's no direct liability on you as the employer if one of your employees suffers sexual harassment by a third party. The Employment Rights Bill seeks to address this and will extend liability to you as an organisation for harassment of your workforce by third parties, which could be contractors coming in, it could be your clients or residents, or it could be their families or whoever else, but anyone other than your employees. So this is quite a significant change, and there is quite a lot of planning you need to think about to ensure that you're complying with these duties and minimising risk. And this new liability is not just limited to sexual harassment. It's going to apply to all of the protected characteristics under the Equality Act. You will have a defence if you've taken all reasonable steps. So the defence is increasing in terms of burden on you from reasonable steps to all reasonable steps. And if you can show that, then you'll have a defence. We're expecting guidance on specifically what's required to succeed with that defence through the regulations under the Employment Rights Bill and also through the ECHR as well. So we can share more information on that when we have it. There's also the proposals to change laws around firing and rehiring. So this is where ultimately you're trying to change someone's terms and conditions of employment, but they won't agree. And so you dismiss and offer employment on new terms as a way of getting them to agree to those or to impose those changes. Examples of where that might apply are, for example, we've had significant increases in national insurance contributions in the last budget. Organisations or some organisations that had more favourable other benefits, which were a cost to the organisation, may have sought to kind of reduce some of those in order to meet the costs, additional costs of national insurance contributions. And so they'd have to go through this sort of a process if they couldn't get employees to agree voluntarily. The government's manifesto pledge was to abolish fire and rehiring, and that kind of came off the back of the P&O ferries situation, which I'm sure most of you heard of in the press. They haven't actually gone that far in the Employment Rights Bill, but they have significantly increased the legal bar to be able to fire and rehire. Currently, you would just need to show that you've got a sound business reason and then consult with staff, and you'd be able to potentially impose those changes. Under the new proposals, you would have to show that the organisation is in financial difficulty threatening its existence, which is obviously quite, well, a very high threshold, and that you couldn't, the change couldn't reasonably be avoided. So in reality, the effect of those two things is that it's going to be extremely hard to fire and rehire moving forward because it's a very high bar. There's also a new, which is already enforced since January, a new code of practice that has to be followed if you're are firing and rehiring. So just make sure you're aware of that. And if you're looking at this process in respect of 20 or more employees, then the collective consultation obligations apply, and there are some changes to when those rules apply under the Employment Rights Bill as well, and increasing the penalties for non-compliance from 90 to 180 days pay. So what do you need to think about here? Well, if you've got plans to make changes to terms and conditions, it's probably worth thinking about bringing those processes forward before these changes come into effect, because it is going to be much harder going forward. Another new concept under the Employment Rights Bill is the introduction of a Fair Work Agency. This is effectively a new body which is going to have responsibility for enforcing parts of the Employment Rights Bill and other potential pay, particularly relating to pay claims. So whereas currently HMRC have responsibility for enforcing national minimum wage compliance, the new Fair Work Agency will take over that responsibility, but they'll also have similar responsibility in relation to statutory sick pay non-compliance, holiday pay non-compliance, and also non-compliance with the Fair Pay Agreement new pay rates, because effectively once the Fair Pay Agreement terms have been agreed, they will automatically be implemented into employment contracts. And so if you don't comply with those, then employees could use the Fair Work Agency as a way of enforcing those rights. The proposal is that this agency would work and have enforcement powers that are quite similar to how HMRC currently works on national minimum wage. So if you're non-compliant with the national minimum wage, ultimately it's the agency or HMRC currently that do that investigative work. So rather than bringing an employment tribunal claim and the employee having to prove their case and go through either the cost or the time of doing that, ultimately an employee, if they feel that they've the national minimum wage hasn't been complied with, they can go to HMRC will investigate, come to you, you'll have to put all of the evidence together, and then they can issue enforcement powers. So that will be similar for these additional rights of holiday, sick pay, fair pay agreement pay as well. And if they find non-compliance, they issue a notice of underpayment, which is a repayment back to the worker for what's been owed, but they, in respect of national minimum wage, they base that on the pay that they currently receive. So effectively, that builds in an interest payment to the worker. So it's an additional cost that you have to pay. And on top of that, there are 200% penalties as well. Strangely, under the proposals, there is a kind of new power for the Fair Worker Agency to potentially bring employment tribunal proceedings or provide legal assistance to workers where they're not looking to bring the claim themselves. Potentially, the agency could bring proceedings on their behalf, which is a completely new concept, something that we've not seen before, and we don't know, the extent to which that's something that they would look to do in practice, but obviously quite a fundamental change. So those are the kind of big H changes. As Pardeep said, there's a much broader range of changes coming in, but these are probably the most significant ones to start familiarising yourselves with now and getting used to. We're here to help you on this kind of journey if you need it, so we can provide kind of strategic advice on compliance with the Employment Rights Bill changes. We're developing tools to help you comply with the changes. We have an updating service to ensure that you stay up to date with all of the changes. At the moment, we just have the bill. That will soon become an act. But then after that, we're going to get lots and lots of regulations to set out the real detail how all of these different bits apply in practice. We can also support you with training managers on how to implement these changes, updating contracts and policies. And we also have a service called Help, which is a yearly agreement for proactive, practical, commercial and sector-specific employment advice for a fixed fee, and also with the benefit of legal expenses insurance to cover employment tribunal claims if you need it, as well as access to kind of template documents and guidance notes and things like that as well. So we are here to support you, whether you just need a small level of support or whether you need a lot of kind of hand-holding through this process. We can kind of tailor the support to that. So thank you very much for listening. And I'm now just going to pass over to Derek, who I think is just going to share a few things from the bank perspective.
Thanks, James. I will let you catch your breath, I think, after that whirlwind tour of the Employment Rights Bill. Yeah, my name's Derek Breingan. I head up the Virgin Money Health and Social Care team across the mainland UK. We provide debt solutions and we provide banking services, but one of the things that we do is with our exposure to stakeholders across the country, we get insight to some of the key things that are going on within health and social care sectors. So I found out about the Employment Rights Bill over 12 months ago at a conference in Scotland. Was quite surprised at the amount of content within that was being proposed at that time. Even I think last month there was a survey done of social care providers, and 30% that were surveyed had no idea what the Employment Rights Bill was bringing, although there was some awareness of something happening. So I think it's on us to promote and educate and share best practice for what will have financial implications to the sector going forward. We held an event with Care England about 6 weeks ago, and we had Rose Thomas-Willis, who's the Deputy Director of the Department of Health and Social Care, who came to do a talk to us. She's leading on the Fair Pay Agreement discussions. She was quite open and honest about what the implications of that may be, but they are not defined at this stage. What we do know is that the intention is to have this launched in April 28, and there's a lot of work going on in the background to build up towards that. The key questions on that evening were, so what's the financial implication? Because although 500 million is being made available to councils for the cost of this, it's not fully funded, as James said. So some figures were bandied about, but there is no, at this stage, there is no number to be attached to what this means to an average provider. There was some sentiment in the room and from the DHSC that it would be between 15 pence and 70 pence per hour, but there is no firm number as yet. So we'll need to watch that closely. Clearly, with the Employment Rights Bill, there's also additional costs. James has mentioned training, additional costs for making sure that your systems and controls are in place, that you can audit and monitor, particularly staff rotas and staff sickness. James has given an example there of where the implications of your statutory sick pay will impact on your funding or your finances going forward. So it is useful to go and do some research into some of the things that we know will be applied at this stage. The national minimum wage continues to tick away in the background, and we're not sure what's going to happen with national insurance within the next fortnight, but that has been talked about as well. What Rose Thomas Willis did say was the consultation is really important to the Department of Health and Social Care. She was particularly pleased that there were providers in the room at that event that allowed her to go and speak face to face to find out what's going on in the sector and what the impact of some of this might be. So I would just ask everybody to try and participate in the consultation, and we'll make sure there's a link available to you for the consultation itself, because if we don't collectively contribute to that discussion, then what will be, and we wouldn't have had our ability to say what we think. So just apologise to people as well on the call who didn't see the slide deck as it was being shown. We will be sending a recording of this event to everybody that attended, and also the slide deck will be available, and it's got James's contact details on there if you need them for any further advice.